From 2014, Alexius Matias, aged 47, has been on a roller coaster in search for justice. This is because in 2013, he lost his job at Ngabu Trading Center in Chikwawa district, where he worked as a branch manager with an agro-based company. Reason for dismissal, his supervisors had suspected he had mismanaged company finances. So, unsatisfied with his dismissal, sooner than later, would Matias take his grief to the Industrial Relations Court for redress over his perceived unfair dismissal. But as it would turn out, until now, it has been a journey of no fruits at all, as 8 years down the line, the Labour Relations Court is yet to lay its hands on the case, to his frustration.
I
was working for Agora as the branch manager in Chikwawa before I got dismissed for being suspected of mismanaging company funds. After being fired, I took the matter to the Industrial Relations Court because I was dismissed without saying my side of the story. This was in 2014, and since then, my case is just being adjourned. The shifts in days mostly happened because of the unavailability of the chairperson to preside over the case. This is so disappointing because it is taking too long for the case to be concluded. It is good to dispose of cases timely, and the justice I am seeking from the court is to know whether proper procedures were followed for my dismissal or not.
As Matias would explain, his frustration at delayed justice delivery has taken away his peace of mind, just like any other person who perceives the court as the last resort for such matters.
My life is stressful every day. I ask myself questions. Did I make the wrong choice to go and present my issue to the court? Or maybe, did I not follow proper steps to have the case sorted at the court? I would have loved to see justice on the matter.
But he isn't the only one lost in this jungle of delayed justice. For over 5,000 others are in such situations or worse off if case files at the Industrial Relations Court are anything to go by. Such distress is shared by George Kaki, president of Employers Conservative Association of Malawi, according to whom the court has cases dating as back as 10 years ago.
It is true that for some time now, for some years, the Industrial Relations Court has not been performing as expected. As a result, there has been a backlog of cases at the Industrial Court. We know some cases are taking maybe over 10 years to be heard. And as a result, again, I think we have seen that the Industrial Relations has over 5,000 outstanding cases that must be dealt with.
Equally concerned at such a huge backlog of industrial dispute cases is Masauko Chamkakara, director for the Legal Aid Bureau. For the Bureau to record over 90% labor-related cases unresolved at the court, Chamkakara feels this is a great hindrance to justice delivery.
We are one of the complainants to say that cases in the Industrial Relations Court are taking too long. We have a good number of over 90% of our Industrial Relations Court cases which have not been completed over the years. So we are one of the complainants to say that there is huge delays in the Industrial Relations Court. It is, as I said, 90%. It is more than what we can ignore, because we know that the cases from the Bureau are not the only cases being held at the court, but it is more likely than not that the case is going to stall. Now, that is not a situation which is sustainable in the long run as far as access to justice is concerned.
Well, this story isn't just about a problem. It is also about solutions. For in the lens of Mauya Msuku, a labor law expert, one solution is to address the human resource deficit at the court in question. In particular, Msuku feels the less than 6 chairpersons at the court human resource arrangement is too inferior of a figure to manage growing labor disputes across the country.
That is very true. If you go to IRC now, you find the cases that are maybe 10 years old plus. You reach a point where sometimes people give up their suing cases. Now, there are a number of factors. One, lack of personnel. For example, now in Blantyre, we only have 2 chairpersons handling cases for the entire southern region. Go to central region, I think there's maybe 2 chairpersons there. If you go to northern region, there's 1 chairperson there. So basically, you're looking at maybe 5 or 6 people handling labor cases for the whole country. It can't be effective, no matter what.
And besides, Kaki thinks there are implications to this, citing disturbance of operations of institutions taken to court.
When cases take long to conclude, it means you are not able to plan for the litigation and the tenant court. When a judgment comes 10 years later, it means you are paying very, very heavily. But last but not least, we should remember the maxim which says justice delayed is justice denied. So if the cases are not settled in good time, then justice denied both to the employer as well as to the worker.
Whilst this could be true, but Chamkakala from Legal Aid Bureau thinks it's time to consider removal of penalties, according to whom are to blame for delays in conclusion of cases.
Through meetings with the judiciary and through our interface with the Law Society, there was a proposal to get rid of the requirement of panelists when we are hearing industrial relations cases, because we understand from the Industrial Relations Court that it is that requirement which delays the whole process. They are having problems to end panels which are required to hear these cases. And because of that, there is a huge backlog of cases because they can't just end panelists to handle these matters. And because of that, we have all these things happening. So we're told that there was a legal amendment to get away with this requirement.
But numbers aside, Msuku proposes the need for a qualified workforce, which he feels lacks with industrial relations courts.
The recommendation for me would be to beef up the personnel. Beefing up the personnel may not necessarily mean establishing IRC in every district. So all we could do is train people to be sitting as IRC in those respective places, and having removed requirement for panelists, then matters would move. Than to have 2 people be moving around, sitting in all districts, for example, in southern region. I don't think that can work.
Such perception is somehow shared by the Parliamentary Committee on Legal Affairs, whose chairperson is Peter Dimba. For him, recent amendments to the Labour Relations Amendment Bill of 2021 could be another solution, as it would help in the structure of the Labour Relations Courts.
It's really understandable why people have such a perception that the Industrial Relations Court is not performing according to the expectations of the people. That is why recently in Parliament we passed the Labour Relations Bill. One of the clauses in that bill is that the Industrial Relations Court will actually have permanent panelists as opposed to the panelists that have been hired on ad hoc basis, and we hope that we're going a long way in making sure that there's an improvement in the performance of the Industrial Relations Court and ensure that the labor-related cases that actually come before it are resolved expeditiously.
All parties heard from the Industrial Court itself through Gladys Gondwe, Registrar of the Supreme Court of Appeal and High Court, affirms something being done about the situation. Moving into the future, Gondwe agrees that the court will have to address the numerical deficit for improved service delivery.
As an institution, there are a number of interventions that have been undertaken to address these challenges. With regard to staffing, we recently conducted a functional review, which has resulted in establishment warrant with an increased number of positions by over 100%. We believe that having more officers, both judicial and members of staff, is going to significantly reduce the workload for the officers and therefore improve efficiency. With regard to resources, in our public reforms agenda, our top priority is to secure a fixed percentage of budgetary allocation, and for a start we are talking about 3%, which we believe would adequately cover our needs as an institution for now, so that we are able to conduct court circuits as and when required. thereby having the matters disposed at an improved rate.
But this is just an aspiration for authorities, a wish for the future to come, and there is no answer on how soon it comes to be fulfilled. This is despite that one wished it came as soonest as yesterday for the inflicted, like Alexius Matias. For MIJ FM, this is Aubrey Kalumpha.